On Monday, February the 26th, 2024, the Liberal Party of Canada tabled new legislation that, among other things, amends the Criminal Code and the Human Rights Act with new variations of hate crime laws. A lot of people have asked about this. Just last week with my episode, there were a number of questions in the comments box about it. So today we're going to talk about some of the highlights from that case. It's over 100 pages, so I'm not going to go through the whole thing exhaustively, but I want to touch on some key points. Hello, my name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So a lot of people have very rightly been concerned about this new hate crime legislation that was introduced by the Liberal Party to the House of Commons on Monday, February the 26th, 2024, that being Bill C-63. We're going to take a look at that today, but I think something that's important to keep in mind at the very beginning is that hate crimes are nothing new in Canada. They've been around in Canada for decades, and really all this act does is beef up some of those laws with higher maximum penalties. There are some new additions that are troubling that we'll look at, but this isn't hate crimes that never existed before that are being created anew. This is some tinkering with laws that have been around for a long time, and there's something that I've been concerned about throughout my entire legal career from when I was first made a lawyer, and it's something we've talked about a lot on Don't Talk TV. Actually, let me just see. I'm pretty sure I did an episode. Yes, episode 16. I mean, that was right at the beginning of Don't Talk TV. Early in 2021, I did a video on Canada's hate crime laws and what they are, because I thought this is something that people really need to know about. I strongly encourage anyone who's concerned about Bill C-63 to have a look at Don't Talk TV's episode 16, because I go through in a lot more detail than I will today the existing hate crime laws, which really inform why these increased mandatory, or not mandatory, but these increased maximums are troublesome and why some of these new definitions are troublesome. So please, I urge you have a look at that. It's a very important episode, and we'll talk about it a bit later, but I think episode 165 is also very important because I looked at how some of these hate crimes are applied or not applied, and that's also very important because there's always the laws it's written on paper, but then there's the law of how it actually functions in practice, and that's very important to look at. So without further ado, let's have a look at some of the key sections of Bill C-63. So here we have Bill C-63. Sorry, I was saying 36 earlier, but it's 63. An act to enact the Online Harms Act, to amend the Criminal Code, the Canadian Human Rights Act, and an act respecting the mandatory reporting of internet child pornography. So there's a number of things that are changed here. We're going to focus on the Criminal Code and the Human Rights Act. So skipping straight ahead to page 59 of the bill, we get into the amendments to the Criminal Code. So of importance here, Section 318 sub 1, that's covered in episode 16, advocating genocide. They're amending the wording of that. So now it's saying that every person who advocates or promotes genocide is guilty of an indictable offense and liable to imprisonment for life. Prior to this act, and currently until this act passes, if it passes, the maximum is 5 years jail. Paragraph 319, that refers to more general hate crime, inciting hatred versus advocating genocide. Maximum 5 years is the new standard. Currently, it's 2 years maximum. 319 sub 2, that's another section of the inciting hatred. Again, currently 2 years, they're proposing to increase it to 5. And then 319 sub 2.1 sub A, that refers to the anti-Semitism or Holocaust questioning law that the Conservative Party of Canada introduced as a private member's bill and then got taken on board by the Liberal Party. I talked about in episode 136. I recommend you have a look at that. I mean, that law is not even a year old. Maximum 2 years. Now they're upping the ante to 5 years. So they really want to hammer people with these charges. They're clearly not satisfied with the sentences that people have been getting. I've talked about that in some other episodes. I touch on it in 165. Now, here's a key here. Definitions are always very important, as I've stated many times on this channel. the definition of hatred was not specifically defined in the criminal code. Now they're defining it to mean the emotion that involves detestation or vilification and that is stronger than disdain or dislike. Now this is slightly more broad than what in the common law had been held by the courts. And again, I cover this in episode 16 in more detail, but the leading case law says that hatred is not a word of casual connotation. This is what the courts have said. To promote hatred is to instill detestation, enmity, ill will, and malevolence in another. Clearly, an expression must go a long way before it qualifies within the definition of section 319 sub 2. So I think you can see, comparing the common law definition that's come through the courts, that this is a broader definition and a lower bar for a prosecutor to achieve to convict someone of a hate crime. And as I've said in those previous episodes I keep referencing, I've had very strong concerns about hate crime laws to begin with. Making it even easier to convict people under them is obviously problematic in my point of view. Now, another section that's very concerning is these additions to the section 810. Now, section 810, this is another very old section of the criminal code that allows for people to get what are colloquially referred to as peace bonds, where people might be familiar with the American term restraining order. That's essentially what a peace bond is. It's the Canadian version of a restraining order. So if someone was fearful of someone else, and it wasn't to the level of a criminal act had occurred, but they had reasonable fear that a criminal act could occur, they could apply for a peace bond. So now they're adding in a specific angle that if you think someone will commit a hate crime, that's what they've got here, an offense under 318, if you have reasonable fear that someone is going to advocate genocide, or if you have a fear that someone is going to question the Holocaust. I should say question because that's what that law says. It doesn't say, I mean, it is a crime to deny the Holocaust, but it's also a crime to question any aspect of the Holocaust. And I listened to 135 to see, or 136 to see my concerns there. But so now you can do peace bonds. That's a bit troubling, but peace bonds have been here forever. What really is problematic is the conditions that can now be imposed on a peace bond if it's under this section. And this is highly, highly concerning. I mean, this is pre-crime and thought crime kind of stuff right out of novels like Philip K. Dick's Minority Report or George Orwell's 1984. So it says that the provincial court may add any reasonable conditions to the recognizance, that being the peace bond, that the judge considers desirable to secure the good conduct of the defendant, including conditions that require the defendant to, now I'll just pause before I get into those conditions, secure the good conduct. Specifically in this case, what we're talking about securing good conduct is to ensure that the person doesn't say things that the court doesn't want them to say. So we're not talking about ensuring that they don't hurt someone. We're now talking about ensuring that they toe the line, they adhere to the orthodoxy of what they're supposed to believe. This is the concern here. They can A, order that they wear an electronic monitoring device if the Attorney General makes that request. So that's GPS monitoring, that's the ankle bracelet where they can tell where you are at all times. B, return to and remain at their place of residence at specified times. So this could be anything from house arrest to you're only allowed out during the day, you're only allowed out for an hour a day. A combined with B could be used to essentially put someone under complete house arrest. They can also order that you're not allowed to consume drugs or alcohol or any other intoxicating substance. And then sub D, they can back that up by requiring that you provide, for the purpose of analysis, a sample of bodily substance prescribed by regulation. So that means urine sample or blood sample, because blood samples, they're being used all the time in impaired driving laws. This is a perfect example, in my view, of how the government, they'll insert highly concerning laws on areas that they figure most people are going to be okay with. I mean, taking urine and blood samples from alleged drunk drivers, most people, they're okay with that. There's no outrage when that law came out, but now that it's there, the precedent has been established. Now they're putting in for if you utter a hate crime, and we've gone over the definition of what a hate crime is. So these are highly concerning developments on laws that have been around for decades that have always been problematic, in my view. So I'm glad that this new variation or this amendment to the criminal code is garnering some interest, because up till now, people just haven't been interested in this. Episode 16 is, I think, the least viewed episode I've ever filmed. I hope that changes, because people need to know about this law. And again, check out 165 to see how this law is applied, because that's the next layer that makes this really problematic. Is we know that only certain people in Canada will in reality be subject to this law. In 165, I covered the case of Crowfoot, Her Majesty the Queen and Crowfoot, where an Indigenous lady ran up to a white woman, punched her in the face, screaming, "I hate white people," and the court determined that that was not hate crime. Yet on the other hand, the RCMP hunted to the ends of the earth to find a guy who'd made some memes for a designated group called Atomwaffen. And as a final example, although this is a case from the United Kingdom, not Canada, their inciting of hatred laws are very similar to ours, and the gentleman pictured here, Sam Melia, was sentenced last week to 2 years in jail for inciting hatred by way of stickers that he'd made. And let me look quickly at a news article to show you what exactly those stickers said that earned him 2 years in jail. This is from BBC. This is actually an article a little bit earlier in the case, January 16, 2024. This article, so activist ran race hate sticker library, court told. The court heard police searched Mr. Melia's house in Pudsey and found a label printer and stickers with slogans such as, quote, "It's okay to be white," unquote, and, quote, "Natives losing jobs, migrants pouring in," unquote. Mr. Story, who I believe is the prosecutor, said further 100-handers branded stickers contain slogans like "Reject white guilt," "Nationalism is nurture," "Labor loves Muslim rape gangs," that's reference to the Labor Party, and a case in Britain where there was allegations that a group of Muslim immigrants had this gang rape system going. There were publication bans, people went to jail for trying to report on it. So that's just quick to reference the context to that comment, because I think context is important. A sticker also said, "We will be a minority in our homeland by 2066, and diversity designed to fail, built to replace." We don't need to extrapolate too much to see some of the same things coming to Canada as in Britain, where an individual is convicted of hate crimes for making stickers that said, among other things, "It's okay to be white." So saying it's okay to be white may well be a hate crime, but physically attacking a white person while saying "I hate white people" appears not to be a hate crime. So looking at that, I think we can start getting a picture of what are these laws really all about and why they're so problematic. Laws like this shouldn't even be on the books for the very reason that they are so open to abuse, in my view, and they're so subjective and open to selective enforcement. And whether selective enforcement is actually a defense is an interesting thing that I might cover in a future episode if there's interest. I recently did some research on that, but it's by no means a slam dunk to make that argument in court. So inform yourselves and take whatever steps you deem appropriate. I think getting involved in politics may not be a bad idea. The Conservative Party of Canada has so far said that they're opposed to this. There's been a bit of mixed messages. I know there was a press release, but I'm going to hold off until they actually have some firm policy in place, and hold off until they're actually in power. Seems very, very likely that they'll be the next government whenever that election is. So, the proof will be in the pudding of what they actually do. This video, of course, is not legal advice. If you need legal advice, you need to speak to a lawyer who can give you specific advice tailored to your situation. So if you want to call me as that lawyer, my contact information is listed below. We're very receptive to suggestions. As I mentioned, this video is as a result of a number of questions raised last week. So please feel free to leave suggestions or questions in the comments box, or email us at the address listed below. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.